The Honorable Justices of the Supreme Court. This court, from recess, now sitting.
Thank you. Please be seated. Before we proceed with calling the next case on this morning's docket, I note that we have some visitors in the courtroom. Is there somebody who could stand up and help identify them for us?
I'm George Shirkovic. This is our government class from Topeka High School, and we're very pleased and proud to be here.
Very good. Thank you for coming. Welcome. Is there anybody who cares to make about a 20-minute speech?
Oh, brave one.
See our bailiff afterward. All right. Thank you. Counsel, you may proceed.
May it please the court. My name is Matthew James Edge. I'm here to represent Mr. Kameron King. What I would like to do, there are a lot of issues to cover, and I'm not sure how many I'll get to. I'd like to start with the one that I hope the court finds the most interesting, issue number 5 regarding multiple acts. In this particular case, there were multiple instances that the state alleged in which Mr. King supposedly damaged his father's vehicles by ramming a truck into them. And Mr. King presented, he denied that he did either incident of this, but he presented slightly different facts to that. The first time he said, well, I wasn't actually the one driving the car, but I was actually inside the car, and Mr. Velasquez was actually the one driving. The second time, the same car was seen ramming the vehicles, and he said simply that he didn't know how the heck that happened. The Court of Appeals ultimately found that it was error not to give a multiple acts instruction in this case, but that Mr. King had in essence presented a unified defense, and I believe that that is really wrong. Now, the law is that when you have allegations of multiple acts and you have a general denial from a defendant, then it doesn't necessarily give rise to the need for a multiple acts instruction, because the jury, if they reject the defendant's story or if they believe the victim, then they will reject the defendant's story in its entirety, because it only has like one fact to it. I didn't do it. And if you reject that fact, then you must have done it.
But isn't that what he said? I didn't do it. Does it make a difference whether he's a passenger in a car or just? He said, he told his father, I didn't do it.
That's right.
That was his defense.
But,
I didn't do it. So why isn't that unified?
That is not a unified defense, because in one instance he's saying, I didn't do it, but I don't know who did. And in the other instance, he's saying specifically that somebody else did it and that he saw them do it.
And how does that change the defense? That it wasn't me. Complete denial that I committed the act. Because
it creates the possibility for jury confusion. I mean, How was there
any evidence suggesting he was an aider and abetter if he was a passenger? I mean, I don't understand how they could be confused if he wasn't the driver that did the act. I didn't do it.
Well, they could believe his story that Mr. Velasquez is driving. Some of the jurors might have believed that, but they might have rejected the story that he didn't know what happened later on.
But I'm not getting the link between imputing what Mr. Velasquez did to him. How would the jury have made that link?
I'm sorry,
how would the jury, even if the jury had believed him that he was a passenger in the car, how would they have made the link that made him criminally liable for the act? Isn't it still, I didn't do it?
Well, one, they could have convicted him under an aiding and abetting theory.
Was that instructed?
I don't believe that it was.
I don't believe it was either.
In any event, they could have said that they could have disbelieved him and thought that he was actually driving. I mean,
that doesn't change his defense, which was I didn't do it. I wasn't the trial.
That's correct, but you're presenting different facts that they may believe or disbelieve. I mean, this is not the case of, like, say, childhood sex abuse, where you have dozens of alleged incidents taking place over multiple years, and you have a defendant who simply says, none of this ever happened, the victims all imagined this, as opposed to somebody who says, well, I was there and I saw somebody else do it, as opposed to, I don't know who did it. In one case, it might make your story more plausible if you say someone else did it, or if you have some alternate explanation for how things happened than simply, I don't know what happened. So even though it's a denial, it's not a general denial. It relies on specific facts. And that, I think, makes these factually separate for the purpose of a multiple acts instruction, and therefore it has to be given. And I would also point out that in every single case where a defendant does not employ an affirmative defense, the defense is a denial. So, and there will undoubtedly be multiple acts cases in which a defendant is not presenting an affirmative defense to all the counts. So there's still going to be a need for a multiple acts instruction in cases where there is a general denial, Your Honor. If there are no further questions about that, I guess I'll like to move on briefly to issue number 6 regarding the alien instruction. And what we're dealing with here is this sort of zombie pick instruction that, so far as I know, is no longer in use. And it's one in which the jury is instructed that a new trial would be a burden on both sides. And this court has found in the past that this is reversible error to give this. It was given here, and therefore we're asking the court to reverse on that basis.
We found that it's reversible error versus just error.
It's error. I think the distinction is whether or not it's clearly erroneous in the context of particular cases. But the court said that it's erroneous. I mean, it's not a correct statement of the law.
You said reversible error, and I'm not aware that we've ever reversed on that issue.
I don't think that it's actually been. Theoretically, it's reversible if it affected the right to a fair trial or something like that, and that's what we think is going on in this particular instance.
But we're in the clearly erroneous arena here.
Correct, Your Honor.
And so, within that context, why would we be firmly convinced that the jury would have reached a different verdict if it had not been for that misstatement in the Allen instruction?
Well, I think that certainly with respect to some of the charges, the jury was on the fence. The record discloses that that one juror had perhaps written undecided on one of the verdict forms. They had questions regarding what the intent to terrorize meant. So, the jury was taking some of these things very closely, and they were apparently sitting on the fence on some of these questions. And the coercive effect of knowing that there would simply be another trial that would be a burden on the state, among other people, which they have to support through their taxes, may well have led them to convict when they might have otherwise had doubt, Your Honor.
But some evidence of juror equivocation is enough to firmly convince us that the jury would have reached a different verdict. It seems like our current opinions have sort of beefed up your burden on clearly erroneous to convince us that the jury would have reached a different verdict. And what I'm hearing is some equivocation, and I'm asking you how equivocation translates into firmly convincing.
Well, I think that if you're sitting on the fence and you know that there's going to be a burden down the line, and you know that you're going to be responsible as a taxpayer for part of that burden, it seems pretty straightforward that you're going to vote for convict if you're equivocating, Your Honor. There are no further questions with respect to the Allen instruction. I'd then like to go back to issue number 1 and deal with the 455 evidence. Here, we have an issue where one of the victims of the alleged criminal threat was asked on cross-examination whether or not Mr. Cameron King carried a gun. And she testified that he had in fact threatened her before in the past. And there was a request, or there was an objection that was made to it, and the court did not deal with it except to say, let's just move on to a different line of questioning.
Where does she give a temporal reference? Where does she give any reference to when the threats happened?
She just simply says before. I don't think she doesn't talk about specific times or instances.
I thought the statement was simply that he's threatened me several times.
Correct, Your Honor. So,
couldn't that have been the fact that there was evidence that she was threatened several times that night? Because there was evidence of him threatening her several times and throwing rocks at her even.
I think the implication was that this was a past event, Your Honor. And in any event,
That's not clear,
if the several times actually referred to the incidents of that night, then they would have been relevant, and the trial court wouldn't have told them to move on. But the trial court felt that they, in fact, did refer to previous events, and that's why they... What's that, Your Honor?
Is that even clear?
I think it's clear enough that there was some taint that entered the trial as a result of this, Your Honor.
But he didn't tell him to disregard. Wouldn't he have done that if he felt like it had tainted the trial?
Well, that's what we feel is incorrect about the judge's decision, Your Honor, that this shouldn't have in fact resulted in a mistrial, particularly with respect to the criminal threat charges, Your Honor.
And we've sort of blurred the plain language of 6455, haven't we? Because it refers to a specific act. And here we have just generically, he's threatened me several times. We don't really have a reference to a specific instance in the past, do we?
Well, I mean, into the fact that we haven't specifically defined it or haven't given it a lot of details, but there is an allegation that something has happened in the past, Your Honor, and that's what I think we have here. I'd like to move on then to the response to the jury question, and I think this really goes to the heart of the jury's confusion with respect to the criminal threat charges. They wanted specifically a definition for the intent to terrorize, and the court gave them a definition of what it means to terrorize. Now, I find this problematic for several reasons. First of all, it is perhaps a correct statement of law, but it's not really responsive to the jury's question. And if you take it that way, then it actually becomes an incorrect statement of law. The distinction is that you have to end up with this. You don't even have to end up with people being terrorized in order to have a successful prosecution for a criminal threat. It merely means that the threat has to be communicated with the intent to terrorize those people. Conversely, even if people end up being terrorized, if what you said to those people was not communicated with an intent to terrorize, then it is not a criminal threat. It's not criminal threat to tell people in a burning building, for instance, that if they do not exit, they will be burned to a crisp. It terrorizes people, the prospect of dying in a fire, but you're telling them to get out of the building. Now, that isn't what happened here. The allegation is that there was a gun shown to people and that they were terrorized as a result of that. The question is, what was the intent with the communication of the threat? And that is really what the jury wanted. They wanted to know what is a good description of an intent to terrorize. And the judge simply told them the result of people being terrorized, what the definition of that is. And that allowed the jury to substitute the testimony of the victims being terrorized for an intent to terrorize. I mean, they can infer that, of course, obviously from that, but it's not the role of the court to actually define these to be equivalent things. Furthermore, in addition to that, the court apparently gave this answer to the jury in written form rather than bringing them out into the court and having Mr. King present. And of course, any time that the district court communicates with the jury is a critical phase of a trial, and a defendant has a right to be present.
Counsel, in your preparation for oral argument, did you review Justice Rosen's recent Burns decision?
Recent?
Burns decision? Decided at the end of October.
I'm slightly familiar with it, but I think it came in underneath the 14-day period, and I haven't had a chance to reflect on it as closely as I should have.
In essence, it says that as long as the defendant has been involved in the preparation of the answer, that the actual communication back to the jury in a written form does not violate the defendant's rights necessarily. Is that applicable here? Do we know if the defendant was involved in the preparation of the answer?
I'm not sure I'm not sure if we're dealing with a silent record or otherwise.
We don't know if Burns might be factually distinguishable.
Correct, Your Honor. I see that I'm out of time. If there are no further questions, I will yield my remaining time to the court.
Any further questions of counsel? Thank you, counsel.
Thank you, Your Honor.
May it please the court, Jennifer Myers, appears for the appellee. Unless there's any other way you requested, I'll just go in the order that the appellant argued these. The first one being issue number 5, that the district court failed to give a unanimity instruction based on multiple acts. The state in its brief argued that it was not a multiple acts case, that this all occurred in one course, that it was at the same location, it all happened within 10 minutes of each other.
But he left and did other things, according to the state, right?
He did. He did leave one location and went.
So they're factually separate. They may not be legally separate. Is that what you're arguing?
Yes. It's all. I think it's all one occurrence, but you are right.
Staying case? You're saying it's staying? It's beating somebody up and hitting them a bunch of times? It's one battery, not multiple batteries?
Yes.
How do you not get a fresh impulse?
It's reaching. I'll give you that. I think the stronger argument for the state in this case is that if it was a multiple acts case, then there was still no error. It would have to find clear error, and there was no reversible error because it was a unified defense. We charged one person in this case. We didn't charge Sean. We didn't charge anyone else. We charged one person, Mr. King. And Mr. King's defense to the whole case was, I did not do it. It doesn't matter if he said, I didn't do it, but I know who did it, or I didn't do it, but I was there and watched it. It doesn't matter. In this case, his defense was, you cannot prove identity. I am not the one who did it. So it's a general denial of the entire thing. So if you are going to find error, I don't believe that it's clearly erroneous. If you have any questions on the multiple acts issue, I'll move on to issue number 6, which was the Allen-type instruction. And the state concedes that it was given, but it was not clearly erroneous. There's no real possibility the jury would have rendered a different verdict. In this case, the evidence was overwhelming against the defendant. I believe it said there was 4 days of trial, over 20 witnesses, and those witnesses included the defendant's own family and neighbors. So the evidence was overwhelming. There was no objection given to the Allen instruction, and there was no indication that there was a deadlock in this case. They did submit questions, but there was no indication that they were deadlocked and that they were pressured into rendering a verdict. So I do not believe that it was clearly erroneous.
Your opposing counsel mentioned something about a juror writing undecided. What was that a reference to?
I believe, just based on the brief, I believed on the jury verdict next to 2 of the counts, maybe it said undecided, and those were with regard to the criminal threat, with regard to which they did have questions of. However, a writing on a verdict, I don't think that we can consider that. We have no idea. Was that one juror who was doodling? Was that the consensus of the jury that there were undecided? Was that maybe they went in and took a first initial poll and everyone said guilty on all counts except for those, and at the very first poll they were undecided? I don't think we can question scribble on the sheet. If they were undecided, they clearly knew they could have come back with questions. They did come back with appropriate questions, and then after the answers were given, they came back. I don't believe that the Allen type instruction had any influence on their decision. The next issue was issue number 1, the 6455, and whether it was whether the court should have granted the mistrial. And this will be an abuse of discretion standard. And an abuse of discretion is no reasonable person would take the same view. And the defendant must show substantial prejudice. And I don't believe that even if you find that it was 6455, he's shown no prejudice in this. This was multiple counts. The facts were overwhelming. There were so many issues going on in this case. I don't know how he's going to say this one statement, which the record shows it was over 40 pages worth of her testimony, and one line of that, how that could show any prejudice. The testimony was, and it's on page 8 of the state's brief, the witness said, "He's threatened me several times. He showed me he's got the gun." I think that supports what happened that night. He did threaten her, and I believe this was the witness who was I think she was even like 9 months pregnant. He was throwing rocks at her. He was threatening her to get off the property. So the fact that she said he's threatened me several times, he showed me he's got the gun. I believe that this is not a 6455 case. She's not talking about a prior instance of conduct, which is what 6455 holds. There's no prior instances. So I don't believe the judge abused his discretion in denying the motion for a mistrial. Are there any questions related to that issue? Okay. And then finally, I believe it's issue 2, where the judge said the intent to terrorize. In this case, it would still be harmless error. Now, the state concedes that the defendant was not there, and I will concede that he wasn't there when they did it, and it was not in open court. However, the court was correct in the response that they gave. It was a legal.
So the defendant's counsel had no input into the answer.
No, I do not believe that's the case. I believe that the defendant's counsel was there because I believe the record states that after statements made by counsel, one of the brief states that after statements made by counsel, the judge instructed. So I believe if counsel were present, it just was not made in open court. But I believe the state, the response given by the court was correct, and it was not unreasonable for the court to give that instruction.
Did defense counsel agree with that response, or does the record indicate?
I'm not sure about that. I have to look at the brief.
how does the response answer the juror's question?
Well, I don't, they want an example of intent to terrorize, and I'm not sure if the appellant is asking that we should give an example, a real world example of how that, and I don't see that being proper for the judge to say, well, if you were to say in a crowd of people, I have a gun and I'm going to shoot you, that would be intent to terrorize. I don't know if this court would uphold that later. So I'm not sure. The question, I think the judge did the best he could with answering the question. What is intent to terrorize? And I think that you define it with the terrorize and the go back to the definition, back to the elements of the crime. What is threat and what is terror? And it appears that it was consistent with Pick, the suggestions made in Pick. He's asking to give the defendant's intent, and that is not listed in Pick. So I think that it was a correct statement of the law. And so therefore, even though it was erroneous to not be done in open court, I don't believe that it was unreasonable, the answer the judge gave, so I do not believe that this court could find that it is harmless error. I'm sorry.
But you would agree a defendant can have the intent to threaten someone, and you can have that victim feeling terrorized, but that still doesn't satisfy the intent to terrorize, does it?
I think you could say, I'm intending to terrorize you. I'm intending to, the definition for terrorize, to reduce to terror by violence or threats, an extreme fear or fear that agitates the body and mind. I think you can intend, a statement could be made to intend to terrorize you, but I think you just have to give a real-world example of that.
If I make a threat to someone, but I'm doing it in jest, it's one of my friends, but my friend doesn't take it that way and is terrorized, I haven't committed criminal threat, have I?
Yes, you're correct. If you just said, I'm going to kill you, if you do that again, and you know that that's not true, then I don't think you're intending to terrorize them, though.
I think what Justice Luckert is saying, that by giving the response the court didn't fill that gap. Just the fact that there is a threat, and here's what being terrorized can be. The intent to terrorize, you have to connect the dots that the defendant's threat was intended to reach that result, and we're not certain that response connected those dots.
But also, there's a reckless aspect for criminal threat, and so I may. Maybe my saying, I'm going to kill you, maybe it was a joke, but if your child is standing right next to your wife and somebody else, they tackle you to prevent that, then obviously, even though it was a joke, it terrorized. It was reckless. You shouldn't do it. So I don't know if they ask a question on intent and you give them that example of intent, are you cutting out the reckless aspect and then leading the jury to believe that they had to intent?
Didn't you cut that out when you charged this case? Looks like it was charged as with intent to terrorize only.
I'm sorry, I'm not sure on that one. But as it relates to the facts in this case, I don't think there was it was not a joking around. It didn't seem that there were no facts that supported that this was just in jest, that these were friends who were just having a party and saying, hey, if you don't leave, I'll kill you. I just don't think that there was any confusion there. So I think that the court, did the best that they could, and, by following the comments in Pick. By giving them the word-for-word instructions, by referring them to the other instructions in the case. So I don't think that it's erroneous, or clearly erroneous, and I don't think it was unreasonable how the court responded to that. Any further questions? Or
I would like to ask you about your arguments regarding the multiplicity on the criminal threat. Where do you... Don't you think that the answer to this is in the first 6 or so words of the statute, which says a criminal threat is any threat? Why do we go beyond that and looking at the unit of prosecution? I'm sorry, the unit of prosecution.
Why don't we just look at that it's any threat?
Right. Why doesn't that phrase define the unit that we're concerned with here?
Well, if we're looking at the law here on the double jeopardy, and do they arise from the same conduct, which that prong has been met, and this is from Thompson citing State v. Schoonover, and if so, by statutory differences, are there two offenses or only one? And so the case law, this is a single statute, and so the case law suggests that when a double jeopardy issue arises from convictions for multiple violations of a single statute, then this court applies the unit of prosecution test. Are you saying that we shouldn't go to the unit of prosecution?
No, I'm saying applying the unit of prosecution test. Why isn't that test answered by looking at those 6 words, which say that the unit is any threat?
Any threat.
Making any threat. A criminal threat is any threat. Isn't the rest of the statute just explaining why the statute, if it stopped right there, would probably be too vague? And so it gives some concrete instances of the type of criminal threat, the content of the threat, and the situation that's made. But doesn't that just give more? But anyway, isn't it just answered by those first 6 words?
Well, and I think that the Wolverton case, the Wolverton court, held that the word communicate requires a declarant and a receiver. So therefore, it's just not a threat. If you make a threat and no one hears it, then how can you be criminally liable for that? If you just say, if you just make a threat and no one else is around and no one hears it, then I don't think that you'd be criminally liable for that. I think you have to have the receiving end hear that, and so each person then who receives that then would be the target.
If I go into this room when the students were here, and from this mic I say, I'm going to shoot all of you, there are, 20 counts?
I think if each person was terrorized by that, then yes, I do believe that.
And is that communicated in any language of the statute?
Well, I believe that the wording, if you look at the other part of the statute where it says to commit violence communicated with intent to terrorize another, or to cause the evacuation of any building. And so that, if you go in and you scream fire and there's no really fire, now that's not multiple counts. I believe that is one count regardless of how many people are in. So they just held that to be one threat that caused the evacuation. But so they could have worded it differently. They could have held, like they did in the criminal discharge of a firearm. They could have said, you made a threat when a human being was present. They could have changed that, but I think by not wording it that way, like they did in the rest of the statute, I believe that they made it for multiple targets. The criminal discharge, I think that's a good comparison. That's just at a dwelling in which there is a human being. It's not multiple acts regardless of how many people are in there. They just said at a dwelling. So in this case, they could have worded it differently, but they used communicate, and if there are multiple targets of that communication, I believe there would be multiple acts.
I see counsel's out of time. Any further questions of her? Thank you, counsel.
Much.
Your Honors, I'd just like to briefly address the unit of prosecution questions that were coming up, and particularly how it relates to the multiplicity issue in the case, in that the statute is actually criminal threat, and the unit of
Counsel,
prosecution
I hate
is
to interrupt, but I don't have in my notes that you had asked for any rebuttal time, and I just looked at our clerks, and they are nodding correct.
Okay.
So
I apologize, Your Honor.
Well, it's no problem for me. I'm sorry that you did not
No, that's
reserve
quite
time.
all right. I don't know that I would have really had that much that would have enlightened you, Your Honor. So,
Thank you very much. Thank you both for your arguments this morning. Court will take this matter under advisement.